After the events of this summer, with the Senate's failure to act at the special session, have any steps been taken, or more specifically, legislation introduced to address the astounding inadequacy of the legislature not having its own legal counsel apart from its reliance on counsel from the governor's office? Is this not the most pressing issue if the legislature is ever to gain equal footing with the executive branch and effectively prevent these circumstances from further destroying our economy and civil liberties in the future?
Thank you. I am in the process of drafting legislation that would give the legislature its own legal counsel. I recently had a discussion with one of the deputy attorney generals, and it finally seems like even the attorney general is recognizing that him providing legal counsel to a separate branch of government is not effective. And so I'm very hopeful that this year that we will be able to have legislation that gives the legislature the ability and not only to hire our own legal counsel separate from the attorney general, which we can do now, but actually gives us permanent legal counsel that is not trying to represent the executive branch and the legislative branch at the same time. And there may be others that are working on this, and so without delaying that any further, I'll let somebody else talk about this.
I haven't said anything for a while. I agree. Coming from the business world, where when you engage a lawyer, you want a lawyer that's only working for you and not for your opponents. You want a lawyer that's only working for you and not for your opponents. And a lot of times when we're drafting legislation or we're trying to craft legislation, we're dealing with things that run against the grain of current law or what a sitting division of government is doing or wants to do. And so the AG's in a position where they've got to, well, they say they can straddle the fence and do a fair job of giving me good advice and also trying to defend the law that's on the books. I would say that's something, if I were in the free world, business world, and I'm hiring an attorney, you just don't do that. You never have a lawyer that's working for both sides. So I'm fully in favor of it. It can manifest in a bunch of different ways. I'm looking forward to seeing Senator Vick's bill, and I do think it's an important issue.
A few things to unpack on that question. The legislature itself does have its own ability to hire outside counsel, and we have done that on a regular basis to defend ourselves in court. The most specific example recently was the state superintendent of public instruction sued both the legislature and the State Board of Education. The State Board of Education used the Attorney General's office as their legal counsel. The legislature used an outside law firm to defend itself in that lawsuit, and ultimately the legislature prevailed in that lawsuit. Another kind of part of that question is the special session and the ability to call ourselves back into session. I almost certainly guarantee that this session we will see a constitutional amendment come out of the legislative session for the legislature to have the ability to call itself back into special session. And that will, if it is approved by 2/3 majority in both the House and the Senate, will be on your ballot in November of 2022. And as far as the governor's executive authority and those issues about potentially changing some of those statutes that were primarily built out during the Cold War era, when the expectation was, you know, if something happened, 3/4 of us would be gone, and those statutes don't quite work in the modern era. That's going to be the topic that probably keeps us around at the end of the day in late March or hopefully not early April, because I think you're going to see many iterations of those bills because there's a lot of moving parts. But I think at the end of the day, we will get something out that makes some changes to those executive powers and gives a little bit more authority to the legislature to have some action.
good, thank you. You may be,
Just add
Please,
one
thank
thing
you.
briefly. In front of me, I have basically the first working draft of the constitutional amendment, as well as a bill that is being worked on in the Senate right now to basically amend Idaho Code 67-465. And some of these things need to be done in conjunction with each other to set the rules in place for how these things will be done. There's been a few folks that have pushed back and said we're trying to strip power from the governor, we're trying to do things like that, we're trying to block ability for emergencies to be called, and that's simply not the case. The best scenario I could equate it to would be you folks are our constituents from all of the districts that we have. We're your elected representatives, and we want to sit up here and talk to you about what's going on. We're thankful that the Kootenai County Republican Central Committee put this thing on for us, but in the case that they didn't, if they didn't want to, we shouldn't be prohibited from still being able to sit up here and talk to you about what's going on. And right now, the symbolism there is that basically if the governor decides he doesn't want us to be able to come in and do a job, then we're prohibited from being able to do it. It's not a fight, it's not a conflict of powers, it's just a balancing of authority to allow us in real times of, because none of us want to call ourselves back in for something that's not a critically important issue. So, but if something goes off the rails like we saw in 2020, we need to have the ability to get back in and help out, help the team, help the state, put our heads together to figure out ideas of how to make things better for everyone. And the more of us we have working on that situation at any given time, the stronger the state's going to be because of it. That's our sheer intent behind the whole thing. And so we're hopeful that we can get these things through, and as was said, there will be a lot of ongoing negotiation about the subtlety and nuance of the words that are used, but you know what, it's important because one's a constitutional amendment and one's a bill, and even though it's just may go into Idaho code, some of these codes have not been touched again for 30, 50, 60 years, and so getting the words right is critical. So we're taking the time to do that so that we can come out and have something that really is going to allow us to represent the will of the people to the absolute best of our ability.
And I fully realize that we veered off of the original question here, but I do need to speak to what's been said. This amendment, it has to pass both bodies by 2/3, and then the voters get to decide, and that's 50% plus one. So that's something that will come before you. I'm sure there will be one, and that will come before you in a year and a half. The other thing, though, for last year there was a real high frustration level. Things were happening that the state got $1.25 billion that the governor spent on his own without legislative oversight and different things. There's tremendous consternation down there about that. And there is a solution, and I believe I've been actively lobbying for this among my colleagues. I believe we're going to pull this off, but there's a legislation compensation board that meets every 2 years, and prior to this last meeting, if the legislature recesses, then we would still draw our per diem. We get per diem every day while we're in session. But they've changed the rules so that if we actually went into recess, then we would forsake that per diem unless we come back into session. Basically, the way this works now, if we do recess, we can recess to a time certain, or there are different ways to do it, and so the legislature will not go out of session. So currently, this is a workaround because we don't have the constitutional amendment. So if something, I do think the legislature needs to be available to be reacted to things that might happen from the federal level. I understand your questions were from the federal level, and I'm concerned there as well. But so we would be able to come back into session. We will not recess, sine die. If we do that, the only way we can go back is if the governor calls us back. If we adjourn, sine die. But if we recess, we can call ourselves back into session as need be. And I do believe that's a workaround. And until such time as a constitutional amendment passes, I believe we can actually accomplish that. The people are saying that, well, we're worried about the legislature staying in session because they've become a full-time legislature. There's absolutely nothing that prevents us from being a full-time legislature right now. All we have to do, except us, which none of us wants that, by the way, I can assure you. That's not my dream job, believe me. But so that's the thing here, and so hopefully this year, if things happen after the normal session is over, we will be able to respond. I brought this up at a concerted meeting a week ago, and pretty much everybody in that room was in agreement with that. So I do think we'll be able to do that, and we have to be there to represent you, because currently the legislature is the least powerful of the branches, and actually I believe constitutionally we're supposed to be the most powerful. So.
Don, I just wanted to reference the other part of the question, and that was the emergency powers bills. Representative Amador referenced it and said that he thought it might keep us in session longer this year to work out the details of these bills. I believe that we're going to get this up front, and it's happening right now. So the House and the Senate have been working together, the leadership of the House and the Senate, to split out the duties of renewing and updating the emergency powers bills. One set of the code, one set of statute says that it's for natural disasters, and that's what the House is working on. And the Senate has the intentional attacks from outside sources or any other reason that we would be attacked purposefully. And that's going to be changed from extreme emergency to extreme peril, so that it's not confusing when you're talking about natural disasters being an emergency. Extreme peril will be an intentional emergency, an intentional attack. I have the language of the latest iteration of it. We've been through several, but there are lots of lawyers that are involved in this process. I haven't been at the center of this, but there are many in the Senate that are, and we were given a copy of the latest that will be printed out of the Senate State Affairs Committee on Monday. The old version of it, that's not very different, it was just from last week, is, if anyone wants to look it up, you can get it on legislature.idaho.gov, and it's Senate Bill 1054. So this new iteration of it is slightly different, but it's essentially the same. And I'm not going to go through and tell you all of the things that are in it, because I've taken way too much time. And my peers up here deserve to have some microphone time as well. Sorry, guys. But I will tell you that it addresses a lot of the promises that we as a legislature made to you during our special session. That we will put safety guards in so that businesses cannot be shut down again. That people cannot be isolated, healthy people cannot be isolated. I won't go through the whole list, but let me tell you that we are remembering loud and clear what we said, and we intend to make good on every single one of those promises.
I'd like to say that the constitutional amendment will be very important in a year and a half when we get to vote on it, to allow the legislature to self-convene. Most other states have this ability. I was looking at the Constitution of the state of Montana, and they only require 50% of the members in both the House and the Senate to agree to a convening before they actually do convene. There have been various numbers thrown around for Idaho's legislature to convene. It started out at about 2/3, and the intent there was we wanted to have the ability to override a governor's veto. Currently, that number is probably around 60%. My personal feeling is it's 50%, just like Montana, because just because we call ourselves in doesn't mean that we can't build more muster for particular legislation that we want to pass once we are in session. We're a deliberative body. We get a chance to consult with each other, present ideas, and persuade people to do what is right for the state of Idaho. One of the things that is also being worked on before we get that constitutional amendment passed is workarounds. Some of these issues, as Mary mentioned, some of the additional ones is who gets to decide whether or not a school gets shut down. Right now, the public health districts have a lot of power. Some of the legislation that's being considered in the House says that the elected board of the school boards, who are elected officials, get to take the input from the health department and then make the final decision, because they're the ones that are closest to the students and to the parents that pay for those schools. I kind of lost my train of thought. One of the other things too, since we can't just arbitrarily limit the power of the governor, there is a proposal right now in the House that says that if the governor wants to spend more than 1% of the regular state budget that comes in to the state, like it did with CARES 1 and CARES 2, he has to get authorization from the legislature. Now, in the past, these non-cognizable funds, as they're called, they're unexpected funds that come in, have been relatively small, usually military appropriations for the National Guard and so forth. But it is the power of the legislature to control the purse strings, not the power of the executive branch. So by passing this one piece of legislation that the governor must obey, he has the option of not calling the legislature in, but then he's sitting on a pile of cash, which is not of very much use to the state or to his political aspirations.
Good moves. That's pretty.
That's all I have. Thank you.
And I just want to add one thing to what Representative Wisniewski said, and that is that there's a concerted effort to return some of these decisions that the health districts are making to elected officials.
Yeah.
Even he mentioned the school districts. I have a bill in the Senate that's passed out of committee and will be voted on Monday or Tuesday, that will not allow any health district orders to go into place without the county commission's approval.